Welcome to the 51st session on liquidation under IBC. We were covering the IBBI regulations for liquidation process. We will continue to do that for this session as well. So let's quickly recap what we have done in the previous session. In the previous session, we have covered regulations 9 to regulation 15 of IBBI liquidation process regulations. Accordingly, regulation 9, we have read that it deals with personnel to extend cooperation to liquidator. Then disclaimer of onerous property. I have explained you that certain properties are absolutely difficult to maintain, more expensive than the value of the property itself. So liquidator may disown these properties, which falls under regulation 10. Then extortionate credit transactions, which we've already covered under the Act as well as under the regulations. Now, regulation 12 speaks about how to make a public announcement by the liquidator for claims. After that, regulation 12A, we have discussed it is nothing but an email ID to be created for the process, and email ID remains same even though the RP changes, he can continue with the same email ID. Then, if the RP is so convinced, he can recommend an early dissolution instead of the entire process of liquidation. And then lastly, progress reports under regulation 15 is what we have understood in the previous session. So let's quickly focus on today's activities. So today we are starting from regulation 16. Regulation 16 talks about submission of claim. We have read in the provisions earlier that operational creditor, financial creditor and other creditors have different procedures to submit their claims. And similarly, regulation 16 of IBBI regulation also talks about how do you submit your claim. Accordingly, a person claiming to be a stakeholder must submit their claim or update an existing claim if already made, and including interest if applicable, before the last date mentioned in the public announcement during the CIRP. Generally, it can be about 30 days of time within which the liquidator will ask for claims, and you must put your claims within 30 days. The person must prove their debt or dues, including interest, as of the liquidation commencement date. How do you prove? I said in case of a financial creditor, the acknowledgement of the fact in the information utility centers will be sufficient, but in case of an operational creditor, they have to give substantial evidences. So without this, your claim cannot be admitted. That's what is regulation 16. And regulation 17 specifically talks about how does an operational creditor submit his claim. An operational creditor, if you're looking at the first paragraph here, an operational creditor other than a workman or employee must submit proof of claim to the liquidator either in person, by post or electronically, but he must do so in Form C, Schedule 2. The existence of the debt can be proven through the records available in information utility or other relevant documents. Once it's proved, your claim can be admitted by the liquidator. When we come to financial creditors, how should they make a claim and what kind of documentary evidence should be given by them is covered in regulation 18. So regulation 16 is about how do you submit your claims. Regulation 17 is submission of claims by the operational creditor, and regulation 18 precisely talks about submission of claims by the financial creditor. So at the first paragraph it says a financial creditor other than a workman or employee must submit proof of claim to the liquidator either in person or by post or by email. However, the specific form prescribed here is Form D of the Schedule 2. In case of an operational creditor, it is Form C. In case of a financial creditor, it is Form D. Both are specified in Schedule 2 of the Act. The existence of the debt can be proven through records available in the information utility or with the help of other relevant documents as far as financial creditors are concerned. Moving forward to regulation 19, it is talking about claims to be made by workmen and employees. If you just go back to two previous slides, Regulation 18, we are seeing here in the bracket that this particular regulation deals with claims other than workman or employee, specifically financial creditor. Going back one slide, this is regulation 17 that deals with claims by operational creditors, but again other than a workman or employee. Hence it is important as to how do workmen or employees make the claims, because it is not covered under regulation 17 or 18. Hence we are moving to the regulation 19 that specifically deals with claims by only workmen and employees. So what does it say? It says a person claiming to be a workman and employee of the corporate debtor shall submit proof of claim to the liquidator in Form E. So we have seen Form C, Form D, Form E of Schedule 2, which are specific formats to be submitted by the respective creditors, whether it is operational creditor or financial creditor or the workman or the employee. They have specified formats. You should fill that up and submit to the liquidator. Where there are dues to numerous workmen or employees, one proof of claim shall be sufficient for all such dues. So let's say in an organization there are 15,000 employees before it went into liquidation. Now, is it necessary that 15,000 employees submit 15,000 forms, or is it enough if they submit one form on behalf of all of them? I think it makes logic or sense to actually allow one form being submitted on behalf of all of them instead of 15,000 forms, and hence Form E can be done in one if there are number of employees. The existence of the debt, how do you prove it? Can be proven through records available with the information utility or other relevant documents submitted by the workman or employee. Now we have seen three classes of claimants. Number one is operational creditor. After that we have seen financial creditor. After that we have seen workmen or employees. Now we are coming to a fourth class, which can be any other stakeholder who is not specified in the previous three classes. In that case, how would he submit his claim? A person claiming to be a stakeholder other than those which are mentioned in 17, 18 or 19, that is operational, financial or employees or workmen, in those cases that person shall submit proof of claim to the liquidator in person in Form G. Now observe the difference. Here we don't have email or any other mode or courier. It has to be in person. Then the existence of the debt can be proven through the records available with the information utility or other relevant documents. Now, regulation 16, 17, 18, 19 and 20, right? These are the 5 regulations, all of which are dealing with the submission of claims. First is general, then specifically by each type of a creditor, and lastly claim by other stakeholders. Let's come to regulation 21, which talks about proving security interest. What do you mean by security interest? First of all, security interest is nothing but a party is thoroughly secured of its debt by creation of a charge or mortgage on the assets of the corporate debtor. The moment a charge is created on the assets of the corporate debtor in favor of a third party to secure his debt, such action is called as creation of a security interest. Now, this security interest which is already created can be modified from time to time or can be totally satisfied, where there will not be any more security interest. So now we are talking about a creditor who is in possession of a security interest. How would he prove the fact that he has security interest on the assets of the corporate debtor? For that, regulation 21 specifies as below. The existence of a security interest may be proved by a secured creditor on the basis of number 1, the records available in an information utility, or certificate of registration of charge issued by the ROC. Those who are not coming from a commerce background, or those who have not studied much about Companies Act, let me tell you in brief. A registrar of companies usually is informed that the company which is registered with him has created charge on certain assets of the company, right? The moment this information is given to the ROC in certain specified formats, ROC will register this charge and give a certificate of registration of the charge to the charge holder. Now, this is a substantial evidence in common law that the charge is created in favor of a secured creditor. So hence, if the information utility does not have any record about such charge being created, the certificate of charge issued by the ROC is a substantial evidence that the corporate debtor has given security interest to the third party to secure the loans borrowed from the third party. The last one, in case these two are not available, then there is a third one. That is nothing but a proof of registration of certificate with the CERSAI, which is a central registry or registration authority for securitization and interest on such securities. So this central registry will receive several charge documents created by several companies or creditors about the charge that they are holding on the company's assets. So either the document information with a document available with the information utility centers, or the certificate of registration of charge by the ROC, or latest the proof of registration of this charge with CERSAI will also be a substantial evidence to make your claim or prove the security interest. Now we will move to Regulation 22, which talks about production of bills of exchange and promissory note. Now, bills of exchange or promissory notes are completely different kind of an asset class. They are called as financial assets. But what happens is the company may have given a certain promissory note to a third party, and the third party wants to claim his money through the promissory note given by the company. So in this case, this is a liability to the company, right? And an asset to the creditor. How do you prove your debt where bills of exchange or promissory notes are issued by the corporate debtor? So we have a specific regulation, Regulation 22. It tells you how to deal with them. If a person seeks to prove a debt related to a bill of exchange, promissory note, or other negotiable instruments or securities for which the corporate debtor is liable. Now watch this word carefully. Wherever the corporate debtor is liable to pay the money on account of a bill of exchange or promissory note or other negotiable instruments, then the relevant bill, note, or instrument or security must be produced before the liquidator, before the claim is admitted. Now, this is enough evidence for the liquidator to admit the claim because he has now verified the instrument submitted by the creditor which can be a promissory note or a bill of exchange or any other negotiable instrument which is produced before him. If he is convinced that this is in order, it's a legitimate instrument, then he may admit the claim. He will not further require any other evidence to substantiate the claims. On Regulation 23, we deal with the substantiation of claims. The liquidator may call for such other evidence or clarification as he deems fit from a claimant for substantiating the whole or part of its claim. So what we have read till now is that the claimants can make a claim in the respective formats prescribed in Schedule 2, starting with Form C, D, E, F, G. And after going through these forms and the documentary evidences submitted by the respective creditors or stakeholders, if the liquidator feels that there is not sufficient information or it is not satisfactory for him to accept this claim, then he may ask for further evidence to substantiate the claim of the respective creditors or the stakeholders. Then we come to Regulation 24. As we are seeing that the parties are asked to submit their proofs of claims from time to time, one at the time of CIRP, another at the time of liquidation. They are continuously submitting claims and also modifying these claims. It may not be easy or it may not be actually economical. This may come with a certain cost to the claimant. Hence, how to spend the money or who should bear the cost of the proof? That's the question. So the answer is given in Regulation 24, which says the claimant himself is responsible for bearing the cost of providing their claim, and hence neither the liquidator nor the corporate debtor will be liable to spend any money on account of proving the debt of a creditor. The costs incurred by the liquidator for verifying and determining a claim will be considered part of the liquidation cost. See, there are two-fold expenses here. Number one is the cost incurred by the claimant to prove his claim. That's one side. On the other side, the cost incurred by the liquidator to assess the claim and substantiate the claim and accept that. So these two costs are two different items of importance. Number one, when it comes to cost incurred by the claimant, it should be absolutely his own responsibility and it will never be reimbursed to him from any source of fund. But on the other hand, if the liquidator had spent any money, had it costed him to actually substantiate the proof, then such costs incurred by the liquidator will qualify as a cost of liquidation and will be dealt with on priority under Section 53 under waterfall mechanism. He will get back all his money that is spent on assessment of the claim. There is one more paragraph about cost of proof. If a claim is found to be false, the liquidator will attempt to recover the verification and determination costs from the claimant and the said details board. So what we are saying is, if there is a false claim, then the liquidator is entitled to receive the cost of verification which he incurred from the claimant because the whole claim was false. Then Regulation 25 speaks about determination of quantum of claim. The liquidator must receive and verify claims from creditors based on supporting documents. The liquidator is required to publish a notice inviting creditors to submit claims within a specified period. Usually this should be about 30 days from the date of publication within which the claim should be made to the liquidator. After receiving claims, the liquidator determines their quantum by assessing the evidence provided. If a claim is rejected, the creditor is notified with the reasons for the rejection and then they can appeal the decision. We have already understood this. When the liquidator actually rejects a claim, either on technical grounds or on not being satisfied or on account of delay in submitting the claims, in all these cases, the claimant can actually approach the adjudicatory authority and seek an order which will allow the liquidator to actually admit the claims which he had earlier rejected. Therefore, determination of the quantum of claim is the sole authority of the liquidator, which is based on the evidences submitted to him. But however, if he rejects any claim or where the claimant is aggrieved by the decision of the liquidator, he may then approach the adjudicating authority for an appropriate relief. So, we have covered about 10 regulations, starting regulation 16 and ending at regulation 25. So let's quickly summarize what we have covered. First one, we said regulation 16 talks about submission of claim generally. Regulation 17 talks about submission of claim by the operational creditor, and regulation 18 talks about submission of claim by the financial creditor. Regulation 19 talks about submission of claims by employees or workmen, and then regulation 20 talks about submission of claims by any other stakeholder. After that, we spoke about proving the security interest of the secured creditor under regulation 21. Then regulation 22 speaks about bills of exchange and promissory notes. They must be produced before the liquidator so that he can admit them as proof of the claims. After that, we have seen that how does the substantiation of claims happen under regulation 23. We said the liquidator may ask for such other information if he is not convinced with the information provided by the claimants. And then we have seen that if the cost is incurred either by the claimant or by the liquidator for verification, these two will be dealt in two different formats. Cost incurred by the claimant will be on his own and nobody will reimburse him, but whereas cost incurred by the liquidator will be reimbursed as priority under section 53 of the Act. And lastly, it says determination of quantum of claims will be the sole authority of the liquidator, and where the parties agree, they may approach an adjudicatory authority for a better relief. So this brings us to the end of session 51, and we will soon discuss the other aspects of these regulations in session 52. Thank you so much.